Good afternoon. I think this makes 14 times, but my name is Michael Pyle, and I'm the Executive Director of the International Law Students Association. Welcome to the championship round, the Sherman and Sterling Jessup Cup round of the 2003 Sherman and Sterling International Rounds of the Philip C. Jessup International Law Moot Court Competition. I'd like to thank all of the 83 teams in attendance here for all of their hard work over the course of the week. We've had 3 days of preliminary rounds, intense competition, intense judging, and some incredible oral arguing. You've worked for 9 months researching the problem, writing your memorials, and practicing your orals, and this is what it's come down to. You should all be very proud, and the quality of the two teams we're going to see here this afternoon is a testament to the quality of all the teams they've seen in their home nationals and to the teams they've met in the preliminary rounds and in the advanced rounds at these international rounds. At this time, I'd like to introduce the two teams, assuming that room back there is soundproofed. Arguing as applicant, we have team number 156 of Murray State University, Russia, Alexei Konovalov and Yulia Romanova. And on behalf of respondent, team number 859, the University of Western Australia, Benjamin Spagnola and Imogen Saunders. The three judges we'll see today are truly expert in their respective fields and are highly appropriate for the championship round. We are honored to have them. The president of the bench will be the Honorable Patricia M. Wald. Judge Wald has been a judge for the International Criminal Tribunal for the former Yugoslavia, Chief Judge of the District of Columbia Circuit Court of Appeals, and Assistant Attorney General at the U.S. Department of Justice. She's a well-known author of several books on criminal law, administrative law, mental health, women's law, and poverty law. She's a graduate of the Yale School of Law. Our second judge today is His Excellency David Scheffer. David Scheffer is Senior Vice President of the United Nations Association of the United States of America. During the administration of President Clinton, Ambassador Scheffer served as the U.S. Ambassador at Large for war crimes issues, and during the first term as Senior Advisor and Counsel to the U.S. Permanent Representative to the United Nations, Dr. Madeleine Albright. He negotiated the establishment of the International Criminal Tribunals for the former Yugoslavia and for Rwanda. He headed the U.S. delegation to the UN talks on the creation of the Permanent International Criminal Court and worked on the creation of special courts of accountability in both Cambodia and Sierra Leone. Our third judge is Maurice Mendelson. Maurice Mendelson is a practicing barrister, Queen's Counsel, at Blackstone Chambers in London and a bencher of Lincoln's Inn. He is a Professor Emeritus of International Law and at University College London, where he has taught since 1987. He was a visiting professor of law at the University of Paris and the Institut des Hautes Études Internationales, Paris. He's also given lectures at many universities and learned societies in Europe, the USA, and elsewhere, as well as at the Academy of International Law at The Hague. Professor Mendelson was the chairman of the ILA, International Committee on the formation of rules of customary international law and is principally responsible for the Association's London Statement of Principles on that subject. So without further ado, in a moment the bailiff will come out and call all rise, and both teams should be ready to participate.
This is now in session. Your distinguished panel consists of President Wald and the Honorable Judges Mendelson and Scheffer.
Good afternoon, agents, members of the public. The court is now prepared to hear from the applicant agents.
May it please the court, my name is Alexei Konovalov. It is my extreme pleasure and honor to appear before your excellencies and to represent the Republic of Italy, applicant in the present case concerning women and children of the Civil War. Yulia Romanova is my co-agent, and Pavel Bulatov is of counsel for Italy. Mr. Benjamin Spaniolo, Ms. Imogen Saunders, and Ms. Sarah Naki represent the Republic of Reston, respondent in the present case. The Republic of Italy would like to make 4 submissions before your excellencies. First, Reston has breached its international obligations and must pay reparations to be distributed to Italy, to be distributed to those victims of systematic rape during the dysfunction Civil War who are now resident in Italy. Second, Reston is in breach of its international obligations with respect to the bribes exacted by Estonian border officials from Annihilation adoptive parents and must make corresponding restitution to Italy on behalf of the parents. Third, Reston is not entitled to exercise universal jurisdiction over Mr. Fred affair. And fourth, Italy has not breached any international legal obligation with respect to the bribes exacted, with respect to the treatment of Cascadian women working in brothels in Italy. And in any event, Reston has no standing to enforce any such obligation. I will be addressing the first 2 arguments, and my co-agent will address the final 2 arguments.
Agent, may I ask whether or not you intend to reserve any time for rebuttal?
Well, certainly, Madam President. I would like to reserve 21 minutes for my speech, 20 minutes for the speech of my co-agent, and 4 minutes for the rebuttal.
Thank you.
Permission. Your Excellencies, would you like me to summarize the facts of the case?
I believe that the court is quite well acquainted with the facts, so unless there are any particular facts that you want to bring to our attention especially, I think you can proceed on to your argument.
Thank you, Madam President. First submission of Italy arises from the systematic rape of Cascadian women by members of Estonian militia during the dysfunction Civil War, the facts which are found in paragraphs 3 and 4 of the compromise. Italy asserts that the systematic rape was in violation of prohibition of torture, war crimes, and crimes against humanity. But before going into the substance of the argument, Italy would like to address the important issue of standing, which Italy has before this honorable court, if your excellencies allow me. The violations in question were contrary to the norms of customary international law, which are arriving from the obligations owed to the international community as a whole, the so-called erga omnes obligations. This honorable court stated in the case of Barcelona Traction Company that all states have legal interest in protection of such obligations, and every state has a right to seek reparation in case of their violation.
Do I understand then, Agent, that you are not arguing to us that Italy has a particular interest in this situation apart from its interest as a community as part of the community of the world to enforce international standards?
Annaly recognizes that the doctrine of erga omnes has never been applied and practiced by international court, and that there is some uncertainty as to who has the right to demand reparations. In particular, official commentary to the articles on state responsibility, to Article 48, which addresses the erga omnes obligation, states that a state which tries to invoke obligations erga omnes and ask for reparations has to demonstrate certain connection to the beneficiaries of the obligations breached, and that it is acting in the interest of these beneficiaries. Annaly intends to demonstrate that there is such connection between the state of Annaly and the beneficiaries of erga omnes obligation breached. In fact, this connection is of such strength that it reaches the level of effective link. The doctrine of effective link has been established and applied by this court in the case of Notenbaum, Liechtenstein versus Guatemala. And existence of effective link is determined by several factors. The most important of which are the habitual residence of a person, meaning that a person has to have a state as a place of habitual residence, and existence of mutual rights and obligations between a state and the person.
Can I just be clear? Are you separately arguing that you're entitled to bring these proceedings or entitled to this redress on the basis of a breach of an erga omnes obligation, and also that by analogy with nationality of claims diplomatic protection, you're entitled to bring these proceedings against Reston? Or are you simply arguing that you have a special standing in relation to the erga omnes obligation because of your particular connection?
Your Excellency, thank you very much for your question. The position of Annaly is that primarily it is relying upon erga omnes violation, and it does submit that it has special connection with the victims. However, alternative submission of Annaly is that the effective link which Annaly possesses with the victims of erga omnes obligations breach entitles Annaly to exercise diplomatic protection over these women.
Even without erga omnes, is your second position one that says you have sufficient links so that even were we to decide that the rapes did not rise to the level of erga omnes, you would still be able to bring a cause on behalf of them under violations of customary international law?
Madam President, most certainly the case of Notenbaum did not have anything to do with diplomatic protection by a state without formal nationality. However, the applicant does contend that even if the obligations in question did not violate obligations erga omnes, diplomatic protection would be a separate basis of standing for Annaly in the present proceedings. I would like to, I'm sorry.
But Agent, can you cite any precedents whatsoever for a state to claim reparations for the crime of systematic rape?
Your Excellency, in international practice, there has not been such a precedent. However, as the violations in question rise to the level of erga omnes, Council would like to direct attention of Your Excellencies to the recent case of Portugal versus Australia concerning the people of East Timor, where Australia has brought a claim on behalf of the people of East Timor. And the court, International Court of Justice, found the standing of Portugal as irreproachable. Of particular importance to the present proceeding is that Portugal, in its fourth submission, has asked for reparations, for compensation on behalf of the people of East Timor. Of course, in that case, the court found that it did not have jurisdiction because the case would affect the rights and obligations of Indonesia. However, the standing of Portugal was upheld in that case, Your Excellency.
Let me ask you a question about the connection. You are bringing these on behalf of women who were raped by members of the militia of what became later on Reston, who are now permanent residents of your country, of Annaly. Do you actually have the identities of those women in hand? In other words, do you know which women you are bringing the claims on behalf, or are you doing it on the supposition that many of the women were indeed raped, and then many subsequently of women from that country came to your country?
Madam President, the facts of the compromise state that Schman de Fer company brought the women who were victims of rape from Cascadia and who are now presently employed by Schman de Fer company. As these women have legally entered the country, they have filed the documents. Therefore, the government of Annalee certainly does possess the information about...
But do the facts in this record tell us that the women that were brought by Chemin de Fer were all women who had been raped? Or even how many of the so-called 2,000 women who were brought to, across the border were in fact raped?
Yes, Madam President, the compromise in the section called Cascadian Women in Annalee in the beginning of that section states that the women were offered employment by Chemin de Fer company, and these women were victims of rape. Therefore, Annalee considers that it does possess sufficient information regarding their status and their personalities.
Did you consider Annalee to be under any obligation whatsoever during the commission of systematic rape to react to it across its border? After all, Annalee is precisely contiguous to this state. Was there no obligation whatsoever to act in real time with respect to this crime?
Well, certainly, Your Excellency, Annalee is a neighboring state to the former state in dysfunction, as well as to states of Reston and Cascadia. Paragraph 6 of the compromise states that Annalee was involved in the peace process and served as an intermediary between the two belligerent sides. Annalee has always been concerned about the violation of human rights in Reston, therefore, but at the time of the Civil War, it has done all it could. After the end of the Civil War, Annalee appealed to both Reston and Cascadia to ensure that justice is brought to the perpetrators and the injuries of the women are compensated and truth is disclosed. Therefore, Annalee is not just bringing a claim for the first time. It's continuous conduct.
Can I, before you proceed, can I just pursue a little further your alternative basis of standing, which, as I understand from what you said, is an analogue to diplomatic protection of nationals, and you rely, I think, on the Nottebohm.
Mostly, but there are also
But is the Nottebohm case applied an exclusionary criterion, didn't it? That's, say, the genuine link is an exclusionary criterion. It's not an inclusionary criterion. It doesn't turn somebody who isn't a citizen into a citizen for the purposes of diplomatic protection.
Your Excellency, most certainly the purposes of the International Court of Justice in the Nottebohm case were different from the present case, because it viewed whether it analyzed whether the naturalized citizen of Liechtenstein was entitled to diplomatic protection by that country, whereas in the present case, the women in question are not formal nationals of Annalee. However, I would like to direct attention of Your Excellencies to the diplomatic articles, to the draft articles on diplomatic protection adopted by International Law Commission in second reading in the year 2002, Article 8 of which allows a state which possesses effective link with a person to exercise diplomatic protection. Of course, it gives further criteria that these persons are stateless or refugees. In the present case, Annalee admits that although facts do not directly state this, there are enough indications that the women in question are stateless because they did not possess nationality of Cascadia and they were expelled from the society of Cascadia, according to paragraph 22 of the compromise. If Your Excellencies permit me, I would like to proceed to another crucial point in the present case, which is attribution of the violations which took place during dysfunction civil war to the state of Reston. Article 10 of Articles on State Responsibility in Part 2 states that a conduct of a movement, insurrectional or other, which establishes a new state on a part of territory of pre-existing state, shall be attributable to the new state. In the present case, the systematic rape which was committed by Estonian militia is attributable to Reston precisely for the reason that Estonian militia established the state of Reston. There are indications in the compromise to this effect. Annalee admits that the state of Reston acquired a characteristic of state entity after the conclusion of agreement on partition of dysfunction, on 14th September 1999.
Was President Raskolnikov the commander-in-chief military official of the faction during the Civil War, which later became Reston?
Madam President, the paragraph 4 of the compromise states that Mr. Raskolnikov was the leader and the commander of Estonian militia. Therefore, it is safe to presume that he was at least in one of the highest positions in the Estonian militia.
You think high enough, or that the record would permit us to make an inference that he was so high in the military that his actions could not be dismissed as that of a rogue officer, but have to be attributed to the successor state?
Applicant is not addressing the actions of Mr. Raskolnikov.
No, but for attribution purposes to the state.
Madam President, but the systematic rape was committed by members of Estonian militia, and analyst submits that these actions are imputable to Estonian militia as an entity and further to the state of Reston. Therefore, the involvement of Colonel Raskolnikov in that actions is important for purposes of command responsibility, however, not for responsibility of the state of Reston.
So you mean that, are you arguing that if there was no command responsibility and these soldiers in the militia were off on a rampage of their own in which they committed systematic rape, that when that particular faction became the state of Reston, the state could be held? Doesn't there have to be some linkage between high officials of the state, the former militia, before you can
most certainly,
attribute the troop? Go ahead.
Most certainly, Madam President, the rationale behind Rule 10 of Articles on State Responsibility, as found in the official commentary, is that there is a substantial continuity between the movement and the state of Reston. And there are several facts in the compromise which show that the Estonian militia established the state of Reston and governed the state of Reston at least until the election of the first president. State of Reston has signed Regional Anti-Corruption Convention on 20th September 1999, according to clarification 11 to the compromise. State of Reston became member state of United Nations in September 1999, according to paragraph 38 of the compromise. Therefore, from the time of partition, there has been a political entity which administered and represented the new state. And analyst admits that in the light of the fact that first president was elected only on 1st November 1999, the only possible conclusion is that organs of Estonian militia were governing and representing the state of Reston.
Agent, I just wish to remind you, are you planning, or is it your plan to have your colleague cover the other issue of Annalee, the bribery corruption issue?
Most certainly, Madam President.
No, is it, if it's yours, I only remind you of the remaining time. If it's your colleague's, fine, go ahead.
It is my issue, Madam President. Thank you. I would like just to...
You may wish to move on to it.
To speak briefly on the issue of amnesty, which was another violation committed by Reston just for a couple of minutes.
It's your choice.
Thank you, Madam President. Amnesty violated international law, as there is a prohibition of amnesty for torture, which is found in, for instance, in the statement of Committee Against Torture in the case of Prosecutor versus Furunzia, which stated that obligations to prevent torture and to prosecute torture are erga omnes obligations. However, our respected opponents will most certainly rely upon inconsistency of practice in the international area with respect to amnesties for torture and other grave violations. However, analyst admits that at the very least, if a state chooses to use its margin of appreciation and to not to prosecute the offenders, it must at the very least ensure the rights of the victims, to ensure that compensation is given to the victims and that violations are recorded. These rules are found in several sources: the statement of the Human Rights Committee, opinions of Inter-American Commission on Human Rights regarding Uruguay and Argentina amnesty, and also in the case of Inter-American Court of Human Rights of Velázquez Rodriguez, which is of persuasive authority for this court.
Agent, if your concern is the victims, why not simply convert your substantial humanitarian aid at this time to Reston, withhold that aid from Reston, and deliver it to the victims who are on your territory now, as opposed to going through this punitive exercise with Reston. Wouldn't that be the more efficient way to dispose of this matter?
NLA has been a humanitarian aid donor to Reston for a long period of time. However, there are other issues which are touched in the present case, such as recording of violation, disclosure of the truth, because these are obligations Reston is owing to the victims. And another aspect is that every breach of international obligations entails responsibility, as has been stated in the Chorzo factory case of Permanent Court of International Justice. And now, with your permission, I will proceed to my final issue, to second issue dealing with the corruption. NLA asserts that Reston has breached its international obligations as being a signature to the Regional Anti-Corruption Convention, and in accordance with Article 18 of Vienna Convention on the Law of Treaties, it was under an obligation not to defeat the object and purpose of that treaty. The principal purpose and object of the Regional Anti-Corruption Treaty, as found in its preamble and explanatory report, consists of attaining common criminal policy by adopting appropriate legislation for protection of society against corruption.
Agent, in respect of your claim for the return of the bribes, in respect of the return of the $2,500 bribes, in respect of those parents who were not qualified, if this court were minded to order such payment, would your government be prepared to return the children?
Your Excellency, NLA does not consider that the conduct of NLAsian parents who chose to pay bribes instead of going through procedures is a commendable one. In fact, it violates the Regional Anti-Corruption Convention to which NLA is a party. And NLA, they most likely will face or are facing prosecution in NLA for giving bribes to foreign officials, although corruption is not crime in the territory of Reston. However, according to a rule found, for instance, in Administrative Decision number 5 of Germany-US Claims Commission in 1925, a state has discretion over how to use the means ordered on when it represents its subjects. Therefore, NLA would not be obliged to return the money to the parents who have violated Estonian law.
No, my concern is that these are parents who ex hypothesi are unsuitable parents to adopt children. They might be pedophiles, for all we know. You are claiming the right to the return of the money that they paid. Does this mean that the children nevertheless can stay in your country with those unsuitable parents?
Your Excellencies, I'm sorry, my time is up. May I answer your
Yes, go ahead and answer the judge's question, but then your colleague should take over at that point.
Thank you, Madam President. According to paragraph 12 of the compromise, NLA possesses special adoption proceedings which comply with international law in accordance with clarification 4 of the compromise. And all the parents who have adopted children or have omitted the adoption proceedings in Reston have been subject to another adoption procedure in NLA. And NLA submits that those who were not suitable for the adoption of the children were refused adoption. NLA also submits that there should be no restitution of children because Article 35 of Articles on State Responsibility states that restitution should not be carried forward if it involves a burden out of proportion on a state. The best interest of the child is the obligation laying upon NLA according to Article 3 of the Child Convention to which it is a party. And NLA admits that returning children to Reston, to a country which faces a desperate economic situation, where they're living in makeshift camps, would be clearly contrary to the best interest of the child, Your Excellencies. Now, with Your Excellency's permission, I would like to pass the floor to my colleague. Thank you.
You may proceed.
Good afternoon, Madam President, Your Excellencies. May it please the Court. My name is Yulia Romanova, agent for the applicant Republic of NLA. Your Excellencies, I will be addressing the following arguments. First, Reston is not entitled to exercise universal jurisdiction over Mr. Fred's affair. And second, NLA has not breached any international legal obligations with respect to alleged mistreatment of Cascadian women working in brothels in NLA. And in any event, the claim of Reston is inadmissible before this honorable court. With your permission, I will start with the argument that Reston is not entitled to exercise universal jurisdiction over Mr. Fred's affair.
Let me ask you a question first, Agent. Why are you coming to this court for what is, in effect, an advisory opinion about whether or not you can exercise, whether or not Reston can exercise a universal jurisdiction? Why isn't it in the nature of universal jurisdiction the country who believes it has power to do so goes ahead and does it? Takes the consequences.
Madam President, the principle of universal jurisdiction, in the opinion of applicant, violates the sovereignty of applicant and the principle of the prohibition of intervention in its domestic affairs, as established in Article 2 of the United Nations Charter.
But Mr. Scheffer affair is still in Annalee, right? And he's presumably safe there unless he's kidnapped. So nothing is happening in effect. What's the injury?
Madam President, Reston declared its intention to prosecute Mr. Schmanderfer to exercise universal jurisdiction over him even without obtaining custody of him. That is, Reston intends to exercise universal jurisdiction in absentia.
Agent, what is the distinction between your claim against Reston that it cannot use universal jurisdiction and your allegation or your further claim that in fact you can rely upon universal jurisdiction with respect to the charge of systematic rape? What is the clear distinction between their reliance on universal jurisdiction and your reliance on universal jurisdiction?
Your Excellency, with respect to the first submission of the applicant does not rely on the principle of universal jurisdiction. It brings the claim for the protection of Cascadian women who were victims of the systematic rapes during the dysfunction civil war. And in case of Mr. Schmanderfer and the alleged mistreatment of Cascadian women, Reston is trying to invoke universal jurisdiction over the national of NLA and with respect to the alleged violations which occurred within the territory of NLA.
Don't you argue that, or wouldn't you believe that with the alleged violation of international law, whether it be a crime against humanity or a war crime, or even genocide with respect to systematic rape, are you not also holding that you have a claim of universal jurisdiction in pursuing those claims against Reston, or is that of no relevance whatsoever to your argument?
Your Excellency, universal jurisdiction is a criminal jurisdiction which is exercised over a person in court proceedings when a state is trying a person without having any connection to him, to the nationality of the offender, nationality of the victim, or the place where the crime was committed. Therefore, the issue of universal jurisdiction appears with respect to the mistreatment of Cascadian women and the claim of Reston and their intention to exercise universal jurisdiction over Mr. Schmanderfer. And the applicant submits that NLA has the primary right to exercise its jurisdiction over Mr. Schmanderfer based both on the territoriality and nationality principles, and also the applicant is clearly able and willing to exercise its jurisdiction over Mr. Schmanderfer. Since the applicant's government established the Blue Ribbon Panel in order to investigate the problem, the work of the panel being ongoing as of the 1st of November 2002, according to the compromise and the clarifications to the compromise.
How long has that proceeded? How long has that commission been in existence now? It's been somewhat over a year, isn't it? More than a year?
Indeed, Madam President. However, the applicant submits that this time should be considered as reasonable, taking into account the complexity of the case and such factors as the number of the victims, witnesses, the number of charges faced by the accused.
Well, what would be a reasonable time, in your view, under international law, for another state which claims to be pursuing erga omnes to withhold its action to see what Annalee is going to do?
Your Excellency, as established in the jurisprudence of the European Court of Human Rights, the time even of 8 years was reasonable in case of Ceremony versus France.
Are you advocating that this court adopt an 8-year period in which nothing can happen?
Madam President, in the present case, the applicant does not contend that this blue ribbon panel and the time of its work is the most perfect way of dealing with the problem, since even it is even less than perfect, taking into account that NLA is a democratic state where regular criminal procedures are available.
But have not been utilized up to now. NLA has not begun any criminal prosecution against Mr. Scheffer, right?
Indeed, Madam President. However, the applicant considers this blue ribbon panel as the effective way of achieving justice and bringing those responsible to account, especially taking into account the statement of President Ms. Contrary, President of NLA, in paragraph 31 of the compromise, who stated that the work of this blue ribbon panel will result on the prosecution of those responsible. And to the contrary, President Raskolnikov, President of Reston, declared with respect to the bribes, after mere reassignment of 10% of border officials, then the problem has been taken care of. And in the present situation, the work of the blue ribbon is still ongoing, and it consists of the prosecutors from the NLA Ministry of Justice. That is, the door is not closed for the victims of the alleged violations.
Agent, supposing that we were against you on the question of time, is it your position that the mere fact that Mr. Scheffer has your nationality precludes universal jurisdiction, or are there circumstances where a person having the nationality of a particular state X could be subject to universal jurisdiction?
Your Excellency, indeed, other factors should be taken into consideration. Namely, another reason that precludes Reston from the exercise of universal jurisdiction is that Mr. Scheffer, the alleged offender, is not present in the territory of Reston. The requirement of presence...
Well, sorry to interrupt you, but I'm not talking about jurisdiction to enforce for the moment, but jurisdiction to prescribe. Is it your position that there is no such thing as universal jurisdiction over a person who has nationality? And if not, what are the crimes over which there is universal jurisdiction? Or to be more precise, why is this alleged crime not one of the crimes in respect of which there is universal jurisdiction?
Your Excellency, the concept of universal jurisdiction exists under international law, but it is confined to the most heinous crimes condemned by the international community as a whole. I'm sorry, Your Excellency.
Sorry, go ahead.
In particular, over war crimes, crimes against humanity, genocide, slavery.
Can I stop you there? Can I stop you there, please? If Mr. Scheffer had taken possession of, say, Heidi, who figures in the facts, and had made her clean his house, polish his shoes, and so on and so forth, that would have been slavery, wouldn't it not?
Your Excellency, we should, in order to answer your question, I would like to...
Yes or no, if possible.
No, if the right of ownership is not exercised over this person.
So is it a question of title? If he has title over her like he has over his horse, then it's slavery, but if he doesn't claim legal title as such, then it's not slavery. Is that your position?
Your Excellency, the issue is the factual treatment of one person of another person.
Right, so if one person obliges another person to work for them, doesn't pay them or doesn't pay them sufficient for them to have any other alternative, forces them to continue to work for that person, is that or is that not slavery?
It is a slavery if this person exercises total physical control over another person.
Now, if in addition Mr. Scheffer forced this person to perform sexual services for him, would that change the position?
Your Excellency, if the total physical control over Cascadian women would be exercised by Mr. Scheffer, this would be the slavery. However, in the present case, the crime of slavery did not take place in NLA.
Well, that's a question of interpretation of the facts. But if I can just, for the moment, just pursue the hypothetical case, if Mr. Scheffer not only kept a woman in his house and obliged her to perform sexual services for him, but also obliged her to perform sexual services for a lot of other people, would that make it less slavery?
Your Excellency, it still would be slavery.
Right, so the only question then is whether on the facts as stipulated in the compromise, these women were or were not subjected to slavery. And you're going to tell us why on the facts they weren't.
Your Excellencies, it is the submission of the applicant that according to the facts in the compromise, the crime of slavery was not committed.
Were these women free to leave? I know the debt, the economic burden which they carried of repayment, but were they free to leave?
Madam President, according to paragraph 29 of the compromise, Cascadian women could leave the dormitory for certain purposes unsupervised.
But usually escorted or supervised. Would a woman in one of Mr. Scheffer's brothels have been allowed to say, I've had it, enough is enough, I'll go on the streets by myself and see if I can't find a legitimate job and get along?
Madam President, indeed it is, practically it is obviously was, it is not clear from the compromise whether they could freely leave. However, we should take into account...
Who has the burden, who then do you believe, as part of your argument, if it's not clear from the facts in the record, whether you say total ownership, sovereignty is necessary to show slavery, and if you don't think that the facts in this record are sufficient to say yes or no as to whether total sovereignty over these women was exercised by Mr. Scheffer, who had the burden of putting whatever was necessary, pro or con, in the record? Was that your burden, or was that the burden of responding?
Madam President, it is our burden to prove that the crime of slavery was not committed in the present case. And the applicant submits that there is no support for the contention that the right of ownership was exercised over Cascadian women, that is, that they were treated as a chattel.
Well, don't we have something in the record about Heidi, who was taken to a medical facility, and when her medical problem was alleviated, then she was forcibly taken back to the brothel?
Madam President, indeed the compromise indicates that Miss Heidi F. fled the dormitory. However, this fact indicates that the liberty of the Cascadian women were restrained. But these restraints on the liberty does not are not sufficient to concede that there was the crime of slavery, since one of the contemporary manifestations of the crime of slavery established, first of all, by Nuremberg Tribunal in Oswald Pochel versus and others case, and later on confirmed by the Yugoslavian Tribunal in Prosecutor versus Kunarac case, that the crime of slavery, the manifestation of the crime of slavery, is compulsory uncompensated labor. However, nothing in the compromise indicates that Cascadian women were somehow forced or coerced to prostitute. The compromise indeed mentions some abuses of Cascadian women. However, it is unclear whether those abuses were replied with a particular purpose to force women to prostitute.
Do we know whether or not these women had to give up whatever compensation they received for their services, for their sexual services, whether that had to be returned to the owner of the brothel?
Madam President, as follows from paragraph 29 of the compromise, Cascadian women were receiving remuneration for sexual services they were engaged in. This follows from the fact that on some occasions they could be deprived of their income. And besides, they were required to pay for their food, clothing, and housing. And when they were unable to pay, they were driven deeper into debt. And these facts also show that their services were compensated.
And this is a yes or no answer, and I'll complete this line of questioning. Is it your contention that as long as they were farmed out for prostitution, as long as they were paid, somebody was paid for their prostitution, then sexual slavery was not committed, and hence we have no internationally cognizable crime. Is that your argument?
Madam President, slavery of any kind, including sexual, also requires the destruction of juridical personality over a person. However, Cascadian women were granted the legal status of permanent residents in NLA, therefore fully retaining their juridical personality.
I don't think that was true in the forensic case in the Yugoslav Tribunal. No question of whether or not they were had their citizenship taken away or diminished in any regard was involved there, was it?
Sir, Excellency, could you please repeat the question?
Sorry, I'll try to make it simple. You talked about the Yugoslav Tribunal case. I'm saying in that case, correct me if you think I'm wrong, I don't remember that there was any element of their having lost any of the elements of their citizenship or of their juridical personality at the time that they were considered to be in slavery because they were holed up in particular places and made to do both menial work and to satisfy the sexual desires of the militia.
Madam President, in Prosecutor versus Kunraj case, the Yugoslavian Tribunal held that there was sexual slavery. However, in the present case, Cascadian women were not forced to prostitute. They engaged in prostitution practices as a way of getting money, which is the essence of prostitution. And the applicant concedes that certain violations of the human rights of the Cascadian women did occur in the territory of NLA. And if it did take place, they would certainly come within the ambit of authority of the Blue Ribbon panel. And Your Excellencies, if you allow me, I will address the final submission of the applicant. With your permission, I will deal with the procedural part of this argument first, proving that the claim of Reston is inadmissible before this honorable court, the claim on behalf of Cascadian women working in brothels in NLA. This claim is inadmissible due to the following reasons. First, according to the well-established rule of exhaustion of effective local remedies available in the state of NLA, resort to annihilation courts by Cascadian women working in the Schmadefer Company's brothels was necessary for an international claim on their behalf to be admissible.
Well, don't you admit yourself that you have this Blue Ribbon Commission which would rather discourage Reston from pursuing judicial local remedies because you've established a Blue Ribbon Commission to investigate all of this, which presumably defers judicial action? You know, your submission is November 2002. You had clear knowledge of the standard that has now been established in the ICC statute that a country has 6 months to prove its capability and willingness to investigate and prosecute very heinous crimes. You've got a process now in the Blue Ribbon Commission that tends to work against that time frame. How do you explain that?
Your Excellency, this Blue Ribbon Commission is established to investigate the criminal conduct allegedly committed by Mr. Schmadefer or the representatives of his company. However, the Cascadian women could apply at least to civil courts of NLA in order to claim that the employment contract with the Schmadefer Company should be declared void. Moreover, the work of the Blue Ribbon panel shows that domestic proceedings in NLA are still pending. Therefore, local remedies available in NLA are not exhausted also for the reason that, for this reason that domestic proceedings are pending according to the rule of law announced by this honorable court in Interhandle case. Moreover, Your Excellencies, the claim of Reston is inadmissible since Reston lacks locus standi to bring the claim on behalf of Cascadian women. I'm sorry, Your Excellencies.
Why don't you take 60 seconds to finish in about 2 sentences the core of this argument, and we'll add 2 minutes on to the respondent's time. Go ahead. But timekeeper, let us know when the 2 minutes are up. Thank you.
Thank you, Madam President. So that even if our respected opponents claim that violations of erga omnes were committed in the present case, the applicant admits that the crime of slavery, which falls under the category of violations of erga omnes obligations, did not take place in the present case. And finally, NLA has not breached any international legal obligations relating to the alleged mistreatment of Cascadian women working in brothels in NLA. Since this mistreatment was committed, if it was committed, it was committed by Mr. Schmandefer or by the representatives of his company, and these acts being the conduct of private parties, is not as such attributable to the state of NLA. That is all for my submissions. Thank you, Your Excellencies, for your attention.
Thank you, Agent. We'll now hear from the agents from Reston. Proceed.
Madam President, Your Excellencies, my name is Spagnola, and together with my co-agent Saunders, I appear for the Republic of Reston, respondent in this matter. Your Excellencies, with your permission, including the extra 60 seconds, we shall each address the Court for 22 minutes and reserve 2 minutes for rebuttal. For rebuttal, right?
That's fine.
Your Excellencies, I shall address the first 2 submissions for the respondent. These correspond to the applicant's prayers for relief A and B. In its first submission, with respect to prayer A, the respondent refutes any liability arising out of the rapes perpetrated by individual militia members during the Dysfunctian Civil War, before the state of Reston came into existence. In its second submission, with respect to prayer B, the respondent denies liability to repay bribes paid by Annihilation citizens to Estonian border officials. My co-agent will address the third and fourth submissions for the respondent, which concern the treatment of Cascadian women in brothels in Annihilate and the question of universal jurisdiction. If it please the Court, I turn first to the question of the rapes. The respondent contends 3 issues raised in the applicant's submissions. First, that the state of Reston is not to be held liable either directly by attribution or indirectly by a failure to prosecute for the rapes. Second, that the applicant lacks standing to seek damages in this court. And finally, that damages are in any case not payable. Addressing then the question of state responsibility, and first the issue of attribution. The applicant has relied on the rule reflected in Article 10.2 of the International Law Commission's Articles on State Responsibility for the purpose of attributing responsibility for the actions alleged to be actions of the Restonian militia to the new state of Reston. The respondent notes that this rule is not reflective of customary international law. The commentary cites no state practice or opinio juris. Instead, the cases referred to in the commentary, the instances in Venezuela, in Mexico, and indeed the Iranian situation, are all instances of Article 10.1, the application of a rule in the case of succession of governments within an existing state. The rationale in the respondent's submission that underlies the rule in 10.1 does not extend to the case of 10.2, the case of new states. The rationale was explained in the Bolivar Railway Company case by umpire Plumley. The umpire said that the nation is responsible for the obligations of a successful revolution from its beginning, because in theory it represented ab initio a changing national will, crystallizing in the finally successful result. In the present case, there can be no changing national will because there was no nation.
So is the natural implication of your argument, Agent, that in a civil war between 2 factions in a once unified state, when it results in a division and 2 new states are formed, that there is no way that any war crimes, crimes against humanity, genocides, no matter how heinous, that were committed by one side of the Civil War can be attributable to the nation which emerged out of that side? I mean, isn't the state responsibility draft itself some evidence of the development of customary international law that we could look to for what seems to be a compelling, logical case?
Madam President, you have indeed summarised the respondent's position. The respondent submits that the case...
I meant to ask you a question.
Indeed, Madam President. The respondent submits that while the rule in Article 10.2 may be desirable, certainly the International Law Commission adopted it, the respondent submits that there is no state practice or opinio juris which would bind the state of Reston at customary international law to any such rule. However...
Could I, even if you're right, is the logic behind the rule in 10.1 in some way different from the rule enunciated in 10.2? That's to say, can you explain to the court how the principle underlying the rule that a change of regime within a single state results in responsibility, why it's different here?
Certainly, Your Excellency. In the case of a succession of governments within an existing state, there is a continuation of an international legal personality. The state continues to exist despite the internal civil difficulties. It is no concern of international law who the government of that state is. However, the international responsibility can attach to a personality because that state never ceases to exist. In the present instance, though, dysfunctia ceased to exist and 2 new states were formed. The respondent clearly accepts responsibility for acts of the Restonian government since its formation, but contends that there is no rule in customary international law which would make the new state of Reston responsible for acts which occurred prior to its formation.
Agent, it certainly sounds like a brilliant way for a state to avoid any responsibility for heinous crimes by simply conspiring to self-divide and thus extinguish any liability. Isn't it the case that, in fact, there is a continuum here, and it's the president of your country? He was a leader of the militia that allegedly committed these crimes. He's now the president of the new state. Are you arguing, first I'd like to know, are you arguing that he himself has no individual criminal liability for these actions? And then as the head of a government, the actual voice of the government, the mind behind the government, the creator of the new state, that state itself has no liability, no culpability for these crimes?
Your Excellency, the respondent admits that Colonel Raskolnikov may be liable in terms of personal, individual criminal responsibility. However, what we are concerned with is the question of state responsibility. Even accepting the rule in Article 10.2 is custom, then the respondent submits the requisite continuity between the ruling organisation of the militia and the new state of Reston is lacking. That continuity is described in the commentary as being such that they are effectively the same entity. In the present case, the applicant can point to only one link, to the election of President Raskolnikov. One man, Your Excellencies. One man who, according to paragraph 4 of the compromise, lacked control over the movement. Unlike the cases of Bolivar and the Pinson case and the French Venezuelan Railways cases, here we have a democratic election. President Raskolnikov rules in Reston not because he was the leader of the Restonian militia, but because he was chosen by the people of Reston in a democratic election.
Right. Saddam Hussein also won by 100%, and he has 30 years of atrocity crimes to answer for, so I don't find that entirely convincing.
Your Excellency, the respondent submits that there is no inference to be drawn from the compromise as to the legitimacy of the elections. The respondent submits that President Raskolnikov is president. He does not rule because he was a member of a military junta, as is the case in certain other states. He rules in Reston now because he was elected.
You're in effect telling us that if you had a civil war, and certainly if Raskolnikov and his group had won the entire war, including what is now Cascadia, and taken over the entire country, you would not be making the argument. You would agree that 10-1 in succession was the proper result.
Yes, Madam.
Now, suppose, as happens more and more often in this modern world, you don't have complete victories. You have negotiated settlements of civil wars. You may end up with a federation, such as we had in Bosnia, or you may end up with 2 countries agreeing to live side by side, etc. You're telling us that because of that practical, real-worldly element, all kinds of war crimes, crimes against humanity that may have been committed by a clearly discernible element that ended up in a sovereign, with a sovereign nation, are by the board. They can just forget about them.
Indeed not.
That doesn't sound as though that's promoting international law and responsibility.
That is not the respondent's submission, Madam President. Indeed,
Okay.
Individual criminal responsibility
No,
will
individual,
lie.
I'm talking about state. I know individual would be done regardless of what happened to the states.
Madam President, it is the respondent's submission that on the practice and opinio juris of states currently forming customary international law, there is no rule by which a new state, formed as Your Excellency has described, can be held responsible for the acts of such a group. Your
What would,
Excellencies,
what would have to happen to this International Law Commission and this draft state responsibility? If it got adopted by a certain number of states, would that be enough to satisfy your demands that it evidenced customary international law?
Your Excellency,
You have to begin someplace. You're saying step one is no good, but when would sufficient number of steps be? Obviously, opinio juris, whatever the right phrase is, there were enough of them around to adopt this particular draft, suggesting that it represents some kind of expert opinion.
Madam President, as this Court noted in the North Sea Continental Shelf cases, the widespread and representative participation of states in a convention may form a rule of customary international law. However, the present status of the Articles on State Responsibility is merely articles of which the General Assembly has taken note. There is in the respondent's submission insufficient uniformity or constancy, insufficient widespread and representative participation of states adhering to such a rule for it to exist at custom. Your Excellencies, if I might turn to the second ground of responsibility alleged by the applicant, and that is that Reston has, by its grant of amnesty, breached a customary international law duty to prosecute and provide an effective remedy in respect of the rapes. Your Excellencies, the respondent notes that the state practice and opinio juris, insofar as it reflects any customary international law duty to prosecute such crimes, is qualified in respect of certain states in certain circumstances. In particular, it is qualified in the case of states which must weigh, on the one hand, the need for prosecutions, and on the other, the competing needs for achieving peace and stability, looking to nation building, to national reconciliation, national healing, allowing the nascent judicial and political organs of these new states to mature, to solidify. The practice of these states, Your Excellencies, is one of amnesty, not one of prosecution. The respondent notes that in the last 30 years, some 36 states have granted amnesties. 22 of these, specifically on their terms, included amnesties for crimes against humanity. The respondent refers, by way of example, to the case of Haiti and the 1994 Governor's Island and Port-au-Prince agreements, to the case of South Africa, to the cases of Angola and Mozambique. Your Excellencies, in these examples, the international community has expressed its support for the grant of amnesty. The Haitian amnesty was supported by the United Nations Security Council, for example, in Resolution 841, and in the terms of its meeting number 3238.
But what I don't understand, Agent, is assuming amnesty and assuming, for the moment, the legitimacy of a new state granting amnesty under certain circumstances in order to bring about reconciliation, that amnesty deals with the civil and criminal responsibility of particular individuals. Why would that be any obstacle to another state suing the state, leaving out your first argument for the moment and assuming that it was attributable to the new state of Reston? Why would the amnesties have any relevance as to whether or not another state could sue Reston for these crimes committed?
It would have no relevance at all, Madam President. It's an established principle of the jurisprudence in this court and the predecessor to this court, for example, in the jurisdiction of the courts of Danzig case, that a state may not refer to its internal law.
So you're defending amnesty primarily in terms of it not being an act by the state, which shows what? Why do you care?
Madam President, the respondent refers to the grants of amnesty in the international community to establish that there is no rule of customary international law requiring the state of Reston to prosecute these individuals. It is alleged for the applicant that by granting an amnesty, Reston has breached an international legal obligation to prosecute. The respondent submits that the state practice and opinio juris of states indicates that states, in the case of Reston, states which must face the need to prosecute, but weigh this against the needs for national reconciliation, for national healing and rebuilding. The practice of these states is one of amnesty, and as such there cannot exist a rule of customary international law binding on Reston. Your Excellencies, I turn then to the final two issues in this prayer for relief. They are related. They concern standing and damages. The respondent notes that the applicant has alleged two distinct bases for standing. The first is on the basis of an obligation owed erga omnes. The respondent acknowledges that the obligations in the present case are owed erga omnes to all states in the international community. The respondent further notes that the breach of such obligations gives rise in all states to a legal interest. However, the principles of standing in this court are firmly established. Standing requires that the applicant state possess the substantive legal right or interest in the subject matter of the claim on which it relies.
What I don't understand, Agent, and perhaps you can help me here, is if that's right, what's the point in having an actio popularis? What's the point of the whole concept of obligations erga omnes if you have to show special damage? Because if you're damaged, then why can't you bring a claim in your own right? And if you're not damaged, then why do we need this extra criterion?
Your Excellency, the respondent notes first that the concept of actio popularis is distinguishable from that of an obligation erga omnes. Indeed, actio popularis was specifically rejected by this court in the South West Africa cases. The rationale underlying the erga omnes doctrine is to give rise to some legal interest in all states in the international community, a legal interest sufficient in the respondent's submission for those states to bring an action for a declaration, an action seeking cessation of a breach, or a guarantee of non-repetition of the breach. Thereby, the interests of the international community in upholding the fundamental norms, breach of which gives rise to this right, to this standing, are protected. However, the respondent submits that the legal interest granted by the breach of an obligation owed erga omnes is insufficient to give every state in the international community the right to claim damages in this court. That is an opinion reflected in the decision of this court at paragraph 91 in the Barcelona traction case. It is further an opinion confirmed by the writings of a former president of this court, Eduardo Jiménez de Arecaga, who said that the measures available to states in respect of the breach of obligations owed erga omnes do not include the right to ask for material or moral compensation. This right belongs only to the state which is the direct victim of the breach.
So it's your position that if the claim were merely for a declaration, for example, that Reston was in breach, there wouldn't be this problem about standing. It's merely because Annalay is seeking damages.
Yes, Your Excellency. Okay. Turning then to the second basis on which the applicant asserts standing in the present case, that is akin to a form of diplomatic protection. In the present case, the respondent notes that the effective link test, the genuine and effective link referred to in the Nottebohm case, is insufficient to grant standing before this court. Indeed, in the Nottebohm case, the court at page 17 specifically confined its comments to the case of dual nationality, where two states are competing as to which one of them is the proper party to have standing before this court. This was the reading adopted in 3 years after the Nottebohm case, for example, in the Flegenheimer claim. There, the tribunal held that the theory of effective nationality cannot be applied without the risk of causing confusion. It lacks a sufficiently positive basis to be applied in international law. Your Excellencies, further, if the individuals in the present case can claim, if Annalay can claim standing over the present individuals, the respondent submits that they would nevertheless have to satisfy the continuity of nationality rule. That is, that the individuals on whose behalf the state seeks to exercise diplomatic protection must have been nationals at the time of the breach and until the time of the presentation of the claim.
So you're in effect saying the women from Cascadia have, assuming their own country is in such benighted condition that it can't protect them, that even when they emigrate to a different country, they have nobody who can take over their protection in the international legal sphere. Is that right?
Your Excellency, it is indeed the respondent's submission that in order for a state to exercise diplomatic protection, it must point to the bond of nationality which alone confers this right, as was held by this court.
And this permanent residency that Annalay has given to these women is not sufficient?
In the respondent's submission, it is not, Your Excellencies.
If they gave them full citizenship, it would be? No, you would say that they didn't have the full citizenship at the time that the rapes were committed?
That is the case.
So in effect, they have no remedy in this court.
Annalay has no standing in this court.
No, the women have no remedy.
The women in the respondent's submission could be represented by Cascadia. The rule...
Yeah, but I had assumed in the hypothetical Cascadia is just in such a miserable shape that it can't or won't do it.
Indeed, Your Excellency, and it is for that reason that the applicant relied in the alternative on the basis of erga omnes standing, which the respondent accepts other than for a claim for damages. Your Excellencies, that being the case, the State of Anole has suffered no damage at international law. It was injured neither in respect of its own national interests nor in respect of its nationals, and therefore is not entitled to reparations.
What if Anole had argued, which the basis of is in the compromise, that because of these terrible things that had happened to some of the women during the war, they were fleeing, and because Cascadia was no place they could get any relief from it, they were therefore fleeing to a neighboring country, namely Anole, so that it was, in effect, having to absorb this new population. So in some respect, therefore, it was suffering a special kind of injury.
The respondent recognises that paragraph 6 of the compromise, President Contrary expresses a concern about refugees.
Right.
However, the respondent suggests that this paragraph is not evidence of any refugee flow into Anole. Well,
we know 2,000 of these women came to work in the brothels.
Indeed, Your Excellency, they were brought there by the Chemin Fair Company. However, there is no, in the respondent's submission, no direct evidence and no scope for any inference of any refugee flow by which Anole would be directly injured in the present case. Your Excellencies, I turn finally then to the applicant's submissions in respect of Prayer B and the alleged breach by Reston of its obligation under Article 18A of the Vienna Convention on the Law of Treaties not to defeat the object and purpose of a treaty to which it is a signatory but not a party. Reston acknowledges this obligation and acknowledges too the object and purpose of the Regional Anti-Corruption Convention suggested by the applicant, that is, of encouraging regional cooperation and common laws on corruption. However, Reston notes that this is an obligation not to take positive steps to defeat the object and purpose, as the European Court held in the Opel Austria case. Reston has taken no positive steps to defeat this purpose. Further, it cannot be said that Reston has frustrated any common regional approach to corruption. As is noted at clarification 11 to the compromise, the convention came into force on the 1st of January 1999. Therefore, according to Article 32.3 of the RACC, some 14 states in the region have already ratified the convention and have therefore implemented the relevant legislation. In the words, again, of the Opel Austria case, it cannot therefore be said that Reston has in any way jeopardised the attainment of the object or purpose of a treaty to which it is a signatory, but not a party.
Surely that obligation is an obligation not simply to undermine the effectiveness of the treaty inter se amongst all the other parties, but in relation to the particular state which is a signatory.
Your Excellencies, I note that my time has expired. Madam
You
President,
may go ahead and answer the judge's question.
Thank you. Your Excellencies, the respondent indeed accepts that the scope in the present case is not limited inter partes. However, the convention is a regional one, and the object and purpose of the treaty is concerned with a regional approach to corruption and common regional laws, given that 14 states have already implemented such legislation and that it is perfectly possible for Reston itself to implement such legislation in the future. The respondent submits that it cannot be said that Reston has defeated the object and purpose of the RACC.
Thank you.
May it please the Court.
We'll hear from your colleague.
Madam President, Your Excellencies, in its last two submissions, the Republic of Reston seeks to uphold human rights in relationship to the treatment of Cascadian women in brothels in Anole. Accordingly, the third submission for the respondent is asking this court to declare that Anole has breached its international legal obligations with respect to these women. The fourth submission for the respondent is asking this court to affirm that Reston is entitled to exercise universal jurisdiction over Mr. Schmanderfair, notwithstanding his absence from the territory of Reston. Your Excellencies, turning to the question of Anole's own international legal obligations, this submission rests on three issues. The first of which is that the treatment of the women can be properly characterised as slavery. The second is that Anole had a duty to prevent, investigate and punish acts of slavery occurring within its territory, which it has not done. And the third is that Reston has standing in this matter. Your Excellencies, this treatment can be characterised as slavery in a process of two steps. The first is to show that it fits the definition of trafficking and of forced prostitution as a crime against humanity at customary international law. And the second is to show that both trafficking and forced prostitution are encompassed in the customary definition of slavery. Your Excellencies, forced prostitution as a crime against humanity requires 4 elements to be fulfilled. The first is that people must be forced to engage in acts of a sexual nature. This force can be through either detention or by duress. As is evidenced in paragraphs 28 and 29 of the compromise, the Cascadian women were forced to engage in acts of a sexual nature, both by detention and by duress. Secondly, the perpetrator must have expected to gain some advantage from this conduct. As Mr. Schmanderfair expected to gain a financial advantage, this element is also fulfilled.
Do we really know enough from the record in the compromise to know that the terms that these women were operating under once they got to Analay amounted to forced prostitution? They were farmed out, and then whatever money they received for their services was put on a ledger against whatever amount the travel cost. But we don't know the extent, for instance, once the passage was paid, whether they were overbilled for the passage. Once the passage was paid, could they say, goodbye, I'm off on my own? If they walked out on the street and said, I've had enough, et cetera, et cetera. And if indeed we don't know enough in the record, since you're bringing the claim, your state doesn't that mean that you fail?
Indeed, Your Excellency. There are 2 answers to that question. The first with dealing with the proof, the burden of evidence for proof. Indeed, Reston is bringing this claim against Analay and would normally have the burden of proving the evidence. However, as this court suggested in the Corfu Channel case, where one country has exclusive territorial control over elements of evidence, the court is willing to infer to a certain degree elements of evidence which are not included. However, secondly, Madam President, the respondent submits that these elements can be found on the compromise. The fact that the women may not have been overcharged for their passage is not relevant to the crime of trafficking. Rather, the crime of trafficking only requires that the transfer of persons be done by fraud or deceit. As is clearly evidenced in the agreed facts of the compromise, these women were promised jobs as nannies or domestic servants in Analay. However, when they got to Analay, they were put to work in a very different situation, that is, as prostitutes in brothels. Therefore, the element of fraud and deceit is fulfilled. In terms of remuneration for their services within the brothels, there is evidence in paragraph 29 of the compromise that when the women were sick, that they were removed from the work schedule and were thus driven deeper into debt. Furthermore, the women were forced to pay inflated prices for their food and for their accommodation under the Schmanderfair Company. However, Your Excellencies, there is also the elements of deprivation of liberty, as evidenced in paragraph 28, that is, the women were not allowed to leave the brothels unaccompanied. When Heidi F. tried to flee the brothel, she was returned by Analasian police. Furthermore, as is evidenced in paragraph 28 and 29, the women were subject to frequent mental and physical abuse at the hands of their captors. This is, in the respondent's submission, enough to establish the elements of the crime of forced prostitution and further the crime of slavery.
Agent, even if you can establish the elements of those particular crimes, I'm still confused as to how you can establish the elements for a crime against humanity. This is one individual, Mr. Schmanderfair. At what point does he himself commit a crime against humanity in accordance with the elements for a crime against humanity?
Certainly, Your Excellency. In terms of the elements for a crime against humanity, 2 need to be met. The first is that the perpetrator must carry out either a widespread or a systematic attack on a civilian population, and the second is the perpetrator must have full knowledge of either the widespread nature of that attack or the systematic nature of that attack.
Is anyone else involved other than him in this enterprise?
Your Excellency, there is no specific individuals named who might have been involved in this enterprise from the Schmanderfair Company. However,
why do you include the crime against humanity in your charge sheet then? Why not just sexual slavery, rape, etc. against this individual? How does it rise to the threshold requirement of crime against humanity?
Excellency, it is the respondent's submission that it is the very widespread nature of this crime which elevates this crime to a crime against humanity. Because it was committed not just against 1 victim or even 10 victims, rather it was committed against 2,500 Cascadian victims.
But by 1 perpetrator?
Yes, Your Excellency. However, individuals can commit crimes against humanity. if it is in the context of a widespread attack. In this case, Mr. Schmandefer has committed a crime against humanity in the context of a widespread attack against the civilian population.
But that's where I have the problem. You say in the context of. I don't know what the context of is. It's his context and his alone.
Indeed, Your Excellency. However, it is the respondent's submission that there is no need for more than one person to be involved in a crime against humanity if the other elements are met. That is, in this case, if it is sufficiently widespread and it is aimed against a civilian population, it does not matter whether Mr. Schmandefer acted alone or with other people also carrying out this crime.
That might be, it might be a compelling argument on your universal jurisdiction against Mr. Schmandefer, but I'm having a much harder time on your other claim, against the state of Annalay, if it is one individual. What you're basically saying is anytime somebody is running a brothel, a big brothel that involves some drug trafficking, then the state may be held responsible. You're basing that on the fact that there were a few complaints and that the state didn't pay what you think was the requisite attention?
Certainly, Madam President.
That's enough to rise the entire business up to not only an ergo omnes, but a, whatever the other part is, a right of action underneath that.
Certainly, Madam President.
Do we have any precedent for that?
Yes, Madam President. If I might turn to that submission now. However, I would refer the Court to pages 15 and 16 of our written memorials for further evidence on why this behaviour is indeed slavery, contrary to the applicant's submissions. However, Your Excellency, the respondent seeks to attribute responsibility to Annalay not because of the actions of Mr. Schmandefer are attributable. Indeed, the respondent agrees that the actions of an individual are rarely attributable to a state. Rather, the respondent in his oral submissions seeks to rely on Annalay's own breach of its international legal obligations. That is, Annalay had a duty incumbent upon it to prevent, to investigate, and to punish acts of slavery which were occurring in its territory, and Annalay did not do so. Your Excellencies, this duty is sourced from a number of conventions, including the Convention on the Elimination of All Forms of Discrimination against Women, the recent Transfer in Persons...
Is this a treaty which is binding on both parties?
No, Your Excellency.
Can you tell us what's the basis of legal obligation then?
Indeed, Your Excellency. The respondent is seeking to assert that this is a customary obligation.
On what basis?
Your Excellency, for example, the Convention on the Elimination of All Forms of Discrimination against Women has 170 ratifications, and the article to which the respondent refers to, Article 6, has no reservations. The respondent...
Have you ever demonstrated, have you ever demonstrated that Reston itself has adopted legislation and enacted it into law which actually implements universal jurisdiction for this crime? Can it be prosecuted in the domestic courts of your country?
Your Excellency, indeed, that relates to the respondent's second submission. There is no evidence on the compromise to suggest whether Reston has exercised its own domestic legislation as to entitling it to exercise universal jurisdiction or not. However, Reston's question before this court is whether Reston is entitled to exercise universal jurisdiction over Mr. Schmandefer in conformity with international law. If this court were to decide that yes, it could, as Reston submits, then no doubt Reston would implement such domestic legislation, allowing it to do so over Mr. Schmandefer.
Are you, on the question of the widespread ratification, why should we infer from that that there's more than the fact of widespread ratification? Why does that demonstrate that this is a rule of customary law? And if I can also, at the same time, ask this question, you referred to the fact that there's no reservation clause, no doubt referring to, alluding to the North Sea continental shelf cases. Are you aware of the numerous criticisms which have been made of that part of the reasoning of this court in that case in respect of reservations, and what's your answer to those criticisms?
Certainly, Your Excellency. In regards to the first half of your question, the respondent relies on the widespread ratification of the Convention as evidence of state practice. As the North Sea continental shelf case, the court did decide that conventions, if they had sufficient ratification, could be evidence of customary international law. The respondent relies not only on this convention, but also a number of conventions, each of which enshrine the duty to prevent, investigate and punish as evidence of state practice and opinio juris to the existence of such a duty at international law.
I thought that this court decided that practice under a treaty was simply practice under a treaty in that case, but carry on.
Excellency, in regards to the reservations question, the court in the North Sea Continental Shelf case stated that if a treaty had, a section of a treaty had a number of reservations...
Now, I know what, I think the court knows what the court said, but I pointed out to you that this particular part of the court's holding had been widely criticised. Can you answer those criticisms?
Certainly, Your Excellency. In regards to the criticisms that reservations do not impact on the opinio juris of states, the respondent would submit that if there are a large number of reservations to a particular part of a convention, then perhaps it can be argued that that particular article does not enter custom because of the lack of opinio juris accompanying that article. However, regardless of the court's stance on this issue, the fact that there are no reservations to Article 6 means that those states' opinio juris in ratifying the convention does support the respondent's submission that this is a customary duty, that is the duty to prevent, investigate,
purely neutral?
punish. Sorry, Your Excellency?
Why is it not just purely neutral on the question whether there's a customary obligation?
Your Excellency, the respondent submits that the existence of a number of treaties which incorporate this duty, not only the Convention but also the Transfer in Persons Protocol, as well as 6 slavery and trafficking conventions, as well as decisions of this court, the United Nations Human Rights Committee, the Inter-American Court of Human Rights and the European Court of Human Rights, all which hold there is a duty to prevent, investigate and punish breaches of international law, support the respondent's submission in this claim. That is, that this duty is one of custom and it is binding on the applicant in this case.
Is the court entitled to take into consideration any evidence of widespread non-compliance with treaties?
Certainly, Your Excellency. And that
do we have any such here?
No, Your Excellency. Indeed, it is the practice of states that they do prosecute such crimes. Indeed, there is examples. For example, the United States Department of State requires 89 states to report to it annually in regards to measures taken against trafficking and slavery within their countries. Of the 7 steps which the United States Department of State recommend, 18 countries fully comply with each and every one of these steps. A further 59 substantially comply with most of these steps.
But what you're telling us, I think here is, based on the facts and the compromise, is that if a state signs its treaty and then receives written complaints, it does not tell us the number in the compromise. It could be 2, it could be 200. That's a deficiency in the record. Receives complaints that in fact some violations of the treaty are going on and does not immediately or within a short time initiate some kind of action that they have thereby taken themselves up into the erga omnes hierarchy and can be sued by any other country, I think according to your theory, any other country in the world. Do we have any precedent for that?
Your Excellency, there is no precedent in that no case has been brought before this court on an erga omnes obligation.
Why would we begin that trek with a case where the record is that dubious?
Your Excellency, the respondent would submit that the record is not dubious in terms of this case. Anale has not just deferred investigation, rather investigations that were made to its police officials and to its governmental departments.
But it just says here written complaints. We don't know how many, we don't know what state they were in, we don't know anything else. I mean, every day in every prosecutor's office in the United States, there are hundreds and thousands of complaints that don't, many probably valid, that don't get prompt attention.
Certainly, Your Excellency. In regards to the nature of the complaints, is evidence at paragraph 28 that the complaints allege substantially the same conduct which was reported in the ILSA report. That is, the complaints alleged the conduct of slavery. In terms of the number of complaints, it is the respondent's submissions that the duty on states is to investigate every complaint that is made to its police officials or to its governmental departments if there is a probability of that complaint being true. Your Excellency, this is the decision of the Inter-American Court and the European Court of Human Rights in a number of cases.
Agent, it's so very important for parties to come to the bar of this court with clean hands. And in this case, Reston, where so many of these particular women that you are so concerned about in Anale were in fact systematically raped, they ended up in Anale, and now you're charging Anale with violations of laws pertaining to sexual slavery, etc. Is there any reason for us to believe in the political credibility of your claim before the bar, or is this simply expediency on your part?
Your Excellency, the respondent submits that its claim is founded in international law and a desire to protect these women.
But this court's time is very valuable. What is the credibility politically of your government lodging this claim?
Your Excellency, the respondent does not seek to condone the rapes or indeed to excuse them. The respondent submits that they were a terrible aberration. However, the respondent submits that it is not Reston's responsibility for these rapes, nor is it Reston's responsibility to punish them, given Reston's competing needs in this case. However, on the other hand, we have now a situation which is still ongoing in Cascadia, a situation where women may still be kept in brothels in conditions of slavery. It is the respondent's submission that such a clear case of slavery should surely be considered by this court as one where erga omnes obligations should be upheld for the first time. Indeed, slavery was one of the first categories recognised as erga omnes, the duty not to enslave and to protect from slavery by this court.
Why shouldn't we wait a little bit longer and see if this Blue Ribbon Commission comes with a slam-bang series of recommendations? Why should we proceed to make this fairly giant leap into international jurisprudence by being the first case to activate a right of action under the omnis ergia? Why not give them a little bit more time?
Your Excellency, there are two answers to that question. The first is the duty on Adelaide to prevent slavery within its territory and to initially investigate the complaints which were made to its governmental departments is in no way discharged by the existence of the Blue Ribbon Panel. Indeed, Adelaide had a duty to enact some kind of general preventative measure in its state to prevent slavery. It had a duty to investigate these complaints which were made to its governmental departments. It did not do so, and the belated formation of a Blue Ribbon Panel cannot...
Maybe that's what they're investigating, we don't know, the Blue Ribbon Commission, as to what happened to those complaints and why they weren't investigated.
Certainly, Your Excellency, and in regards to an investigation, the Velasquez Court has held that that investigation must be effective in that case. The respondent submits in this case the investigation has been going on for at least 18 months. This is not a period where an indictment has not been brought or charges have not been laid, but rather, as is evidence in the clarifications to the compromise, nothing has happened. No reports have been made.
We don't know that. We simply know that the commission is in existence and hasn't reported. We certainly don't know that they haven't done anything.
Your Excellency, as is evidence in clarification 9 of the compromise, the Blue Ribbon Panel's work is ongoing. It has not yet issued any findings.
Well, I know, but 18 months for a commission, at least in many countries, is not a disproportionate amount of time.
Certainly, Your Excellency. However, the respondent would compare it to example for the Dartmouth Agreement in Sudan, an agreement to stop forced prostitution and slavery, which only came into existence in February 2002, yet was reporting by July 2002 of the same year. The respondent would also refer to the facts behind the Nera Alegria case in the Inter-American Court of Human Rights, where an investigative body in that situation took only 5 months to report to the Senate, even though it was a highly complex investigation involving questions of state responsibility, conspiracy, and the deaths of over 100 people. Your Excellencies, the respondent further submits that it does not need to exhaust local remedies in order to obtain a declaratory judgment before this court. Your Excellencies, the respondent is not seeking reparations before this court, and as such does not need to show that local remedies have been exhausted in Adelaide before it gains standing before this court. This is the decision of this court in the Ambitialis case, as well as the view of the International Law Commission in its report to the General Assembly in 1977 and 2001. Accordingly, Your Excellencies, the respondent submits that Adelaide has breached its duty to prevent, investigate and punish slavery, and Reston has standing to seek a declaration. Your Excellencies, the fourth submission for the respondent relates to universal jurisdiction. Reston submits that it is entitled to exercise universal jurisdiction over Mr. Schmanderfair, notwithstanding the fact that he is not present in Reston at the time. Your Excellencies, the starting point for the respondent is to submit that states are, as a consequence of their sovereignty, entitled to extend their criminal jurisdiction to acts which occur outside their territory against people...
So why are you coming to us if you think you have that particular right and you're going to exercise it even in absentia, which is somewhat more extreme than exercising it if you have physical custody over a person, to go ahead and exercise it?
Your Excellency, the respondent seeks a declaration from this court that such an exercise would be in conformity with international law. Indeed, this court in the Northern Cameroons case held that where there is a question of customary international law between parties that is in dispute, in this case customary international law prohibiting universal jurisdiction in absentia, the court can give a declaration as to that effect, and that declaration will be continuously relevant.
But you would agree that your case would be so much stronger before us if you could demonstrate that you had a domestic law now adopted on the books that sought this sort of extraterritorial jurisdiction over this individual.
Your Excellency, indeed the respondent does not agree with that. The respondent agrees that that would be necessary to show that Reston can practically exercise universal jurisdiction over Mr. Chemandafer. However, the question of Reston's entitlement to international law rests on whether universal jurisdiction in absentia is prohibited as a rule at international law. And the respondent submits that this is certainly not the case. Indeed, there is support for the exercise of universal jurisdiction.
Somebody once said, it may have been me, that the reliance on the lotus principle is the last refuge of a scoundrel. Do you have any justification for reliance on the lotus principle?
Certainly, Your Excellency. The respondent refers to Lord Millett in the Pinochet decision, the Barcelona Traction decision per Judge Nervo, the court in the advisory opinion on the legality of the use or the threat of use of nuclear weapons in 1996, and most recently, in the case of Congo and Belgium, the opinions of 5 of the 7 judges who considered the Lotus position. Your Excellencies, I note that my time has expired. That concludes the submissions for the respondent.
Thank you, Agent. We will now hear rebuttal from the agent from Annalee.
Madam President, Your Excellencies, Annalee would like to offer some responses to the arguments put forward by our esteemed colleagues. First of all, Reston seems to challenge the rule found in Article 10, Part 2 of Articles of State Responsibility. However, it inherently flows from Part 1 of Article 10, which speaks about change of government in a state, because Part 2 speaks about partition of a state into 2 or more states, and it would be manifestly contrary to the intent, to the rationale of this article if a state would, if there would be no responsibility apart from a case when a whole state is preserved. In the present case, only if Restonian militia acquired control of the whole territory of dysfunction would the state, which was formed by a militia, responsible for that. Further, respondents should not be allowed to rely upon to deny their articles, because both parties have endorsed articles of state responsibility, and it seems that respondent is supporting the articles when it is convenient for it. However, it's denying its applicability in other cases. Articles on responsibility were also applied in several cases by this Honorable Court and by other international courts and tribunals. Being a product of International Law Commission and part of the United Nations resolution, it certainly represents an important source and authoritative guidance for this Honorable Court.
Are you saying that the mere fact that the International Law Commission has adopted these draft articles and that there's been a resolution by consensus about them is sufficient to make the whole of the draft articles on state responsibility of the International Law Commission ipso facto customary international law? Is that your position?
Your Excellency, this is not our submission. At the very least, draft articles represent the highest level of scholarly authority, which can provide guidance for this Honorable Court. Further, Reston is stating that amnesty was legal because only President Raskolnikov could be liable for the crimes committed during the Civil War. If Reston is accepting the proposition by applicant that President Raskolnikov is responsible for the crimes, then amnesty would in effect represent a self-amnesty, which is unlawful, as no one can be a judge in his own case. In the case of Hermosillo versus Child by Inter-American Convention on Human Rights, this rule was put forward. And also the examples of amnesties which respondent is relying upon in Haiti and in South Africa are manifestly different from the present case, because in South Africa there were exact measures to record violations and to disclose the truth. In Haiti, the amnesty was criticized as a purely political move, and President Aristide took certain measures to ensure compensation for the victims. In the present case, Annalee is not relying upon a rule that there is an obligation to prosecute offenders who committed torture, although there is such rule. In Furunzia case, for instance, which stated that obligation to prosecute violations of the torture is erga omnes, and therefore the amnesty is unlawful. However, the very minimum obligation is to ensure compensation and recording of violation. The civil amnesty passed by Reston forecloses the possibility of civil redress and therefore is unlawful. Further, with respect to standing, Reston submits that no reparations can be sought by under the erga omnes doctrine. However, in the case of East Timor, this honorable court has confirmed the standing of Portugal when it was trying to seek compensation on behalf of the people of East Timor. Therefore, the statement of Reston is contrary to the practice of this honorable court. And further, with respect to the second issue on dealing with defeat of object and purpose, Reston is reliant on purpose. Your Excellency, my time has expired. May I have a second?
You may go ahead and finish 30 seconds.
Thank you, Madam President.
We'll add 30 seconds on to the Sir rebuttal, too.
Thank you, Madam President. Reston is relying upon purpose of the Anti-Corruption Convention being mere cooperation. However, this is a criminal convention. Therefore, a criminal policy should be adopted, which at least implies criminalization of the basic form of corruption. Furthermore, active conduct of Restonian officials, which is attributable to the state according to Article 4, makes it an active conduct of the state of Reston, which...
But it was acquiescence, not really active conduct. Wouldn't you agree? It was just acquiescence in the bribery.
The public officials themselves, the border officials, were accepting bribes, and therefore this is the conduct attributable to the state of Reston. Therefore, the object and purpose of the treaty was defeated.
Would you say, I know I'm extending your time, so I won't call. Would you say that any time a border guard asks for and accepts a bribe, that you've got a violation of the corruption statute, or the corruption compact, assuming somebody is a party which is cognizable in an international court? Doesn't there have to be some level of proven conduct, widespread, and some showing of the knowledge of the state before a couple of rogue guards can bring you a case before us?
Well,
and did we have that here? 10 guards are all we know about, right?
However, according to the well-respected international newspaper, around 100 people were involved in the bribery, and President Raskolnikov did not adopt any measures to effectively deal with the problem. These officials were only reassigned, which does not even tell us whether they were put into a higher or lower positions. And this concludes the submissions.
Okay, thank you. 30 extra seconds for the other side because of my questioning. The Sir rebuttal, we'll hear from Reston's agent.
Your Excellencies, if I might respond to the applicant's points in the order in which they made them. Firstly, concerning Article 10.2 of the International Law Commission's Articles on State Responsibility, the respondent acknowledges that the unilateral acts of states may bind them at international law. However, as this court held in the nuclear tests cases, it is the intention of these states to be bound that is critical. The respondent would further refer the court to the frontier dispute between Burkina Faso and Mali, where at paragraph 40 the court held that in that case there was nothing to hinder the parties from manifesting an intention to accept the binding character of the rules in that case by the normal method, a formal agreement on the basis of reciprocity. In the respondent's submission, the case is identical in the present instance, where states are indeed open to concluding a treaty on the subject of state responsibility. Turning to the question of amnesties, Your Excellency, the respondent notes that the grant of amnesty in no way constitutes an adjudicatory process passing judgment. The respondent has pointed to the practice of some 22 states in the last 50 years. The respondent further points to the practice of 156 states parties to the second additional protocol to the Geneva Conventions, which in Article 6.5 encourages the grant of amnesty. On the question of standing, Your Excellencies...
Your position on amnesties is that a national amnesty thus extinguishes any international claim with respect to state responsibility for those crimes. Is that your position?
No, Your Excellency. The respondent's position is that the grant of amnesty in the case of states, such as Reston, facing the need for national reconciliation and healing, is permissible in international law and does not breach any customary obligation to prosecute or provide...
But nor does it prohibit states from lodging claims against your state for the commission of these crimes.
That is the case, Your Excellency. Yeah. On the issue of standing, the respondent notes that this court in the East Timor case did not accept that standing on Portugal's application was to be granted. Portugal further only sought a declaration in that case. The court merely noted that the right to self-determination was an obligation owed erga omnes. Further, the International Law Commission in its commentary to Article 48.2b acknowledges that a state seeking reparations for the breach of obligations erga omnes represents a progressive development of the law. Finally, Your Excellencies, in respect of the Regional Anti-Corruption Convention, the respondent does indeed accept that the common legislation criminalising bribery is part of the terms of the convention. However, a state that is a mere signatory and not a party to a convention is not bound to its terms. That is clear in the jurisprudence of this court. Your Excellencies, the respondent notes that its time has expired. That concludes the respondent's argument. May it please the court.
All right, thank you. The court is appreciative of the arguments of the agents from both parties here, and we will retire to deliberate and return when we have finished our deliberations.
All rise.
Good afternoon again. The court has deliberated and will announce its results in a very few moments, but we would like to take an opportunity, very brief, I assure you, for the judges to make some comments and remarks upon what we all think has been a really remarkable afternoon. So I'll turn first to my colleague, Judge Mendelson.
Thank you very much. Well, I think, first of all, that it's a tribute to this competition that we've had submissions of such high quality on both sides. The problem was an extremely difficult one, with many complexities, pitfalls for both parties, and you navigated those bear traps with considerable skill on both sides. We were quite an active or interventionist, perhaps even, court, and we, well, speaking purely for myself, I felt that you our interventions with considerable equanimity, courtesy, and authority, and you're to be congratulated for that. Your written briefs were also very good. It's unfortunate that such a large time elapses between the time when you write your written briefs and the time when you make your oral argument, because there's no doubt been a considerable learning process during that time, and it's naturally, primarily, on the basis of your final arguments that you're judged. But it does mean that if we want to ask a lot of questions in a short time, then we only to some extent can go back to what you, in fairness to you, go back to what you wrote in your written arguments in order to enlighten ourselves. But warmest congratulations to both teams on a splendid effort.
I would like to say that each and every one of you should take great pride in what you have just accomplished, and that includes all of those in this audience who also participated in this and slogged through it for so many months. You've been through an extraordinary experience, and I would like to emphasize that what you just went through is not that far from reality. Yes, there was a hypothetical integration of issues in this problem that was somewhat astounding at times, but you handled it extremely well. And for those of you who continue in this field of work in your careers, and I do so truly hope that this has inspired many of you to do so, you will find that you'll be confronted with these issues in the future. Atrocities are not going to go away. They are going to be committed. And I hope that the skill and expertise of the individuals in this room will be part of the process of bringing individuals justice, as well as the state responsibility, which probably has had a bit of a short shrift in the last 10 years. And this problem brought state responsibility front and center. And I hope to see more of it in the future. But you should all take extreme pride. And as an American, I'm extremely proud that our foreign friends from around the world are in this room and at the tables arguing these cases. I tip my hat to our foreign friends.
Thank you. My remarks are along the following lines. I served as an appellate judge in this courthouse for 20 years, many times in this very courtroom, and I will tell you that some of the arguments, all of the arguments this afternoon, could surely hold their own with the vast majority of arguments and probably do much better than many of the arguments that I heard. So you can consider yourselves in the top professional league already. The second thing that I would like to say is how important I think the exercise that all of you have been through is. Everybody here is interested in the advancement of international law, and I think one of the big advances in the past century, but primarily probably in the past few decades, has been the mechanisms of international courts to actually enforce international law. And if that's going to be done right, it means that practitioners have to know how to handle the very complex doctrines of international law within the context of proceedings, sometimes trial proceedings, sometimes appellate-type proceedings such as you engaged in. That requires a combination of two talents. It requires the scholarly talents to master the body of international law itself, but it also requires all the talent and skills of a litigator. And to bring those two together is really quite a feat, and I think the fact that all of you did so remarkably well in doing that at so relatively young an age is something that I believe we're going to have more international courts in the future of various types, not all one model. And I think that kind of combination of talents is going to be terribly important. I think that to be able to flesh out such complex arguments, especially within the limited pages of the brief and within the limited period of time, which you did itself, also requires a great deal of skill in prioritizing issues. I suppose your job was made harder, if anything, by the fact that you had a very sparse record. I know in my own experience in judging, you are always trying to pull counsel out in terms of what's in the record, on what do they base this on. You had to really grapple with the fact that you did have a sparse record, and I think in that sense you did very well. So I'm not going to prolong everybody's anxiety, but their interest any longer. So I think we will consider the court session substantively closed at this point. And I'm told we proceed over here to announce the awards. Is that right? Which I know you'll all listen to with apt interest. The first award is for the best oralist. Quite a difficult choice, but that's what courts and judges are for. And in this case, the best oralist goes to Mr. Spagnola. The second award that we're announcing is for the best team, and the best team in this case, it's been decided, is Reston. We do have another award. I do want to say there's an old saying in American law that hard cases make hard law, and in this case, hard decisions make hard decisions. But we do have an award for the Analay team, which was excellent.